don't show you the video. That not help you.
There's nothing to worry about, man. I insist, we need information.
No. Alright. It look like a person don't want to press me, so here what? If a person don't want to press, we might as well just delete it.
No, David, you cannot delete the information. If you do, you can be charged. It's an offense. You may pay a fine of $3 million or go to prison for 3 years.
In a situation such as this, a preservation notice under Section 17 of the Cybercrimes Act could be prepared expeditiously and served on David immediately. This notice must be in writing. What is the effect of this written notice? This written notice compels persons such as David from altering, manipulating, or destroying the computer data which is in their possession or under their control, and which is reasonably required for a criminal investigation. This notice can be used for any criminal investigation. This notice must include the name of the person who is in possession of the data, as well as an address which can include a physical address or an IP address, email address, or telephone number. This written notice expires 60 days after the date of service. If an officer needs an extension beyond the 60 days, an application must be made before a parish judge. If David deletes the footage after a preservation notice has been served on him, he can be prosecuted. If convicted, he could face a maximum fine of $3 million or 3 years imprisonment. In this case, David, on seeing the notice for preservation, decides to hand over the phone. However, what if David does not hand over the data? After serving the preservation notice, the officer may seek to utilize another tool which is available to him under the Cybercrimes Act of 2015, a production order. This is an order compelling David to produce the data in an intelligible form.
It has been 3 weeks since Kara's excruciating ordeal. One which she did not disclose to anyone because of her embarrassment. Since the incident, she has been struggling with depression and self-deprecation. She is jolted from her trance by an alert on her phone. She does not recognize the number. After receiving the nude photograph that was taken of her, Kara begins to relive the heinous sexual assault that was perpetrated upon her 3 weeks ago. Kara notices that the person who is contacting her is the same person who kidnapped, sexually assaulted her, and caused others to sexually assault her. He debases her further with cruel taunts. To add insult to injury, he proceeds to extort her. Based on this most recent act of degradation, Kara finally builds up the courage to report the matter to the police.
Hello, I'm here to report a rape. Here's the person that did it.
Whilst taking her statement, the investigating officer realizes that she has to engage multiple sections of the Cybercrimes Act of 2015. In this case, she considers the investigative tools under the Act which may assist in securing any computer material needed for the criminal investigation. In this case, the investigating officer prepares an application under Section 18 of the Cybercrimes Act, seeking to obtain a warrant to search the home of ignorant crooks. She wishes to enter these premises to search for and seize the cellular phone or other digital device that contains relevant evidence which is capable of proving the commission of an offense. Under Section 18 of the Cybercrimes Act, a parish judge may issue a warrant where he or she is satisfied by information on oath that there are reasonable grounds to suspect that either there may be computer material in any place which may be relevant as evidence in proving an offense, or where such computer material was acquired by a person for the purpose of, or as a result of, or during the commission of an offense. As indicated, the application for a search and seizure warrant must be supported by information on oath. This means that the constable must either prepare an affidavit in support of his application or swear on the Bible and give true answers before the parish court judge.
Certainly. Dear Lord, as we gather together to conduct the business of this country, this blessed country of ours, we ask for your guidance, your continuous intervention, and to the benefit of all our people. We pray that those who are to join will be safe in getting to where they need to get to. And as we disperse, that we will continue to work on behalf of the people of Jamaica. These and other mercies I ask on all our behalf. In Jesus' name, amen.
Apologies for absence. I have member Hilton, who has a funeral.
And member Hamilton, Tova Hamilton.
Member Tova Hamilton, and also Ms. Golden Campbell, member Golden Campbell, who said that she would be late. That's all I have at this moment. Two apologies and one for being late. So we have those recorded. All right. So in relation to the opening remarks from the chairman, I'll just go through and just give a synopsis of what transpired at the last meeting and some of the issues that were raised. So the last meeting of the JSC reviewing the Electricity Act 2015 was held on March 15, 2023. And before that, March 15, 2023. We are aware that we had taken a break when we discussed that in detail at the last meeting. So basically, arising from the information that was garnered, the matrix was revised and circulated to everyone during the last meeting. The matrix will be used by the committee today and at future meetings, and if needed, will be appropriately updated and recirculated if necessary. At our last meeting, Mr. Richardson gave an extensive presentation of the state of the electricity sector, both globally and in Jamaica, and spent time highlighting issues such as the range of changes in electricity energy prices across the globe, mainly from 2012 to 2018, and some data for 2021, 22, and 23. Also, he went into the different types of market that exist, bundled, single buyer, and unbundled deregulated market structures, and which option or mixed options could be considered for what we wish to achieve in Jamaica. As we are all aware, the policy direction of the government is attaining 50% of renewables on the grid by 2030. And what will be required for us to be able to achieve this target, based on the fact that currently we are at 13% renewables and need an additional 37% within the next 7 years. We also discussed the enabling factors and hindrances, including the phenomenon of the debt spiral based on information gathered from various sources, about large countries and small island states like Jamaica, and of course, issues related to JPS's license, the right of first refusal, as well as the new LNG supplier and LNG plant for which all customers on the grid continue to pay. In terms of the way forward, the committee decided that we should return to the review of the Act and conduct the review as expeditiously as possible so that it can be concluded within the shortest time possible. And as a result, regular meetings would be scheduled going forward. And I think the next meeting is next week, Thursday at 10 a.m., which was agreed from the last time. And of course, we'll set another meeting date after that, as we don't want to lose the momentum based on the, of course, the importance of what we are discussing. There were a few issues which remain outstanding from the last meeting and also from previous meetings, which include the issue raised by Member Hilton concerning the need for the coherency between the SEZ's Act and the Electricity Act in relation to a single developer with a special economic zone, within a special economic zone, who only wish to provide electricity within this zone exclusively and not to the grid. I had indicated at the last meeting that the ministry was in touch with the SEZ and would have an update at this meeting on the matter. Spoke to SEZ yesterday, and they had assured me that I would get something between yesterday afternoon and this morning. Mr. Richardson, I don't know if we have received anything.
So the SEZ had submitted a response via email late last night, and they sent some charts based on surveys they did with their membership. It doesn't really answer a lot of the questions that we had, so we're going to have a follow-up discussion with them.
All right, well, please move that along so that we can come to a conclusion on that, please.
Will do, sir.
Also, the list of tariffs presented at the last meeting for the various countries did not include 22 and 23 prices in per kilowatt hour for Jamaica and some other countries listed. The ministry was asked by Member Jackson to indicate the average prices is for Jamaica for 22 and 23. Mr. Richardson committed to providing the current as well as average prices of all the rate players to the committee, not only for Jamaica, but all the countries listed. He had said the ministry would also develop a graph to show the information. So he briefed us on that when he comes on. Member Paulwell and Jackson requested that the ministry should implement a policy position which had been taken when the LNG infrastructure was created, that the cost of the LNG infrastructure should now be borne by those who are currently benefiting from LNG provided by the LNG supplier, and should be shifted from the JPS customers who have been paying for this infrastructure for years and still continue to carry this burden. I, as chairman, had committed to examining the matter and determine how it could best be addressed and provide a response within 60 to 90 days. That's ongoing. Member Paulwell, we have actually requested the PPA agreements, which I will get to. Which I will get to in relation to requesting it from the OUR. And of course, as I said before, we will follow up on this matter, which obviously is of great importance. So just to clarify that, based on the information that I've gotten so far, MSET understands that LNG matters were handled by the now disbanded ESET, Electricity Sector Enterprise Team, under the Office of the Cabinet. Cabinet officers advised MSET that their searches have turned up nothing with regard to the draft LNG regulations. MSET also searches archives and nothing was found regarding the draft LNG regulations. On the matter of the LNG infrastructure cost sharing, our evidence so far suggests that consideration for sharing LNG infrastructure may not have been a discussion point that was given sufficient stridency for its positive inclusion within the negotiated gas supply agreements. As a result, MSET has requested sight of all the signed LNG natural gas sales agreements from the OUR, and once we have them, we'll provide, obviously, an update to the committee. And further, the committee should note that MSET's capacity to review and provide an informed position on this matter will obviously require external support in order to provide an informed position to the committee. So those matters, members, specifically those two matters, the one that the member Hilton had raised and one that member Jackson Paulwell, are have the attention of the ministry, and hopefully we'll be able to provide more details in short order. I think today we have Mr. Richardson to continue and conclude his presentation. And then, of course, we have the ministry to continue the review. Hopefully by the end of this meeting, I think we'll have a better understanding of where we are in terms of any issues that come up at this meeting. And basically, we can hopefully try and see what work is left and kind of put some timelines to it to see whether we can actually set up a timeline for the conclusion of the review and recommendations. And as I said, I think after today or by the end of this meeting, we will be in a better position to discuss that. So at this point, I would ask Mr. Richardson if he would take over, and then of course, once he's concluded, we can have question and answers and then move on to the review.
Thank you very much, Minister. I'll just share my screen, members. I hope you can see the screen.
Yes, I'm seeing.
Right.
Everybody seen?
Right. So with regards to the discussions that we had at the previous meeting, I'd outlined just in general the costs for electricity on islands within the Pacific and islands within the Caribbean, and also a graph showing the United States and how Hawaii, the island within the continental a part of the United States, how that compared to the continental United States. The continental United States was about 10 to 20 cents, and Hawaii was up in the 30 cents per kilowatt hour. I was asked by the membership to provide an updated graph, which is on screen now, showing the 2023 island electricity prices. This is Fiji, 15 cents, Australia, which is a very large island with huge demand, Palau, New Zealand. So these are the Pacific states coming all the way up to Hawaii. So that's 47 cents per kilowatt hour US, and it's going up to a high of 70 cents in Vanuatu. The average in the Pacific is about 44 cents per kilowatt hour. And then the Caribbean islands start at Antigua and they go along. Guyana, and we have Barbados, we have Suriname, and we have Trinidad. With regards to Suriname and Trinidad for certain, I know they do subsidize their electricity rates significantly, and Guyana does do that as well to some degree, but I do know things will change in the future as they try to offload some of that cost to the government. So the average across the Caribbean is about 28 cents per kilowatt hour based on the numbers here, and excluding the island, the continents such as Suriname, Trinidad, because it's subsidized, and Guyana. With regards to the costs within the island, I received last night from JPS their rate sheets, and they were in Jamaican dollars, but I've converted them to US. So we're on the same basis, and this is for February 2023, the combined energy charge and fuel rates in US dollar per kilowatt hour across the rate classes. So it goes from about 25 cents to up to 35 cents per kilowatt hour. The average across all classes is about 27 cents per kilowatt hour. So ultimately the takeaway is the islands still have a cost envelope for electricity, which is certainly higher than what continents have. And it's necessary to understand that framework in order that when you compare prices to, say, the continental United States to an island state, that they're not apples with apples, but apples versus oranges. And Minister, that's it from my end. If there are any questions, I will remain ready to respond to those.
Yes, I have a question, Minister.
Sure, Member Paula, go right ahead.
Yes. I would like to understand in relation to the comparison, because when I pay my electricity bill, there are a number of components, and I suspect so for other countries. Do these figures have within them the taxation that is paid per kilowatt hour? Because recall, Minister, when I had asked a question in Parliament recently, you had given us a figure of between 36 and 42 US cents per kilowatt hour. And I suspect those figures would have embraced the taxation. So if Mr. Richardson could explain where is the tax element in this, because it goes to the actual cost of electricity to the consumers.
The prices as you see on the screen, they only include the energy charge and the fuel rate. The taxation would be another charge that we put onto it. I didn't receive that from the JPS, so I'm hoping to get an update from that. If I do, then I'll certainly present it to the committee. But it would be reasonable to assume that there is going to be an additional to this because of the taxation rates.
Well, rather than getting it from the JPS, wouldn't it be more appropriate to get these things from the OUR that has the responsibility, and that should have the information at their fingertips?
We can certainly request that as well from the OUR, sir.
Yeah. I think, Minister, because of the importance of the price, it might be, I remember that we have Energy Council meeting later. So as a recommendation, I'll put to the Energy Council meeting in terms of us being always being kept abreast as to the cost per kilowatt hour at all our meetings. But I'll put that to the meeting later.
Agreed, member. Agreed. Mr. Richardson, that concludes your presentation?
It does, Minister.
All right. Any other members have any questions for Mr. Richardson? All right,
you did say earlier, Mr. Richardson, that a response had come from the special economic zone. Probably you could just let us now have on the record what that response is.
Well, I would certainly want the legal services unit of the MSET to opine as well. But what we had received from the SEZ is just a graph of a survey that they've done with across their SEZs. So it doesn't really move the dial forward in a way that we can interpret it and put it within the matrix. And so what we're hoping to do is to have a further discussion with them just to make sure that we're aligned in what they need and what is included within the Electricity Act.
Well, just to be clear, my understanding based on the questions raised by Member Hilton and myself was to see what was the perspective of the Special Economic Zone people on earmarking a special provision to deal with those enterprises within special economic zones. That is to enable them to generate and to supply within their locations their own electricity. So you're saying that having received the report from CESA, she's going to opine on it and then come back and give us their position. Is that so, Mr. Richardson?
That is the hope, but Ms. Campbell can certainly add to that. But I should say it's not a report; it's just a survey which includes graphs. That's all we received.
So member Paul, well, I'm going to follow this up because the truth of the matter is that some specific questions were asked, and if they have not been answered in the format that we want them, then the truth of the matter is that I may ask the committee if they would be aligned in terms of inviting SEC to come and to the committee meeting to be able to answer the questions that we have for them. So we just got the response last night. So let me do some internal work on it. I haven't even seen it myself. So Mr. Richardson, if you could provide me with actually what we asked them and what has come back in summary, and what is the outstanding information that we have not gotten yet, so I can deal with it with the CEO.
Will do, sir.
All right. So we have now. We'll continue the review. Who is leading the ministry? Member legal, Ms. Campbell. Yeah, go right ahead.
Yes, Minister, good morning.
Morning.
On the last occasion when
You're muffled. You're muffled. Do something with your microphone.
am I any clearer?
Yeah, yes, sir. Yes, ma'am.
So on the last occasion, on July 6th, we, in the clause by clause review, we concluded on section 9. If I may be permitted to do a quick recap on that. Now the OUR had
Need some volume though. Not hearing you. Not hearing you at all. Member Golding, Member Campbell, Golding Campbell is having problems connecting. So if you can try and sort out Parliament, please. Yeah, Ms. Campbell, go ahead and let me hear you now.
Are you hearing me now?
Yes, if you could give us some volume, that would be good.
I am not sure, but
yeah, go ahead. That's good. Go ahead.
Okay. So at the last clause by clause review, we completed clause 9, and the committee was presented with the position of the ministry in relation to section 9.1. We agreed to accept the first recommendation of the OUR that section 9.1 be expanded to provide a provision which would permit the minister to grant a license for the activities of transmission, distribution, dispatch, supply of electricity, or for the erection, maintenance, and having an electric line and works over, along, across, or under any street or public road. We also presented that we accepted the OUR's recommendation that section 9.1 could also be expanded to express that Cabinet has a role to play in giving direction on a process to be adopted in the event that the single buyer is unable to exercise its right of first refusal under section 20, subsection 6. We also looked at JPS's comments on section 9.1C, 1 and 3, and they expressed concern that emergency situations not defined in the Act, and there are no conditions stipulated as to how Cabinet may exercise its powers in granting a license in circumstances disclosed under Section 91C in emergency situation, and where due to exceptional circumstances or prevailing economic and financial conditions in Jamaica, it is in the public interest to grant the license. Now we referred the committee to have a look at the definition given for emergency or urgent situation under the Public Procurement Regulations 2018. And there, they define a situation of emergency or extreme urgency to include a situation that arises as a result of events not attributable to or foreseeable by the procuring entity and necessitate the award of procurement contract to effect repairs or remedial action to safeguard the public interest or protect infrastructure or public monies. So our recommendation is that guidance could be had from that, and that it will be made specific to energy generation in circumstances to that effect. Now, in relation to public interest, we indicated that the situations where public interest is held to exist differ and based on the circumstances that present in every occurrence. Now, the Black's Law Dictionary defines public interest as the general welfare of the public that warrants recognition and protection, or something in which the public as a whole has a stake, especially an interest that justifies governmental regulation. Lord Denning, at page 198 in the case London Artists Limited versus Littler, 1969 to Ollie R, defined public interest as a matter which is such as to affect people at large so that they may be legitimately interested in it or concerned at what is going on or what may happen to them and others. And based on that, we believe that there is sufficient guidance from case law and otherwise that Cabinet could consult in considering whether public interest justifies the decision to award a license in the circumstances presented in Section C13, and we believe that any reasonable body making a determination on any matter would have regard to those. We also recommended that Section 91C2, which allows for Cabinet to determine, to approve the grant of a license in order to accommodate an offer from a foreign government to the Jamaican government that will benefit the electricity sector. We believe that should be deleted. And if any such occurrence happen in the future, that the provisions under Section 913 could accommodate any such situation. The OUR in relation to Section 9(3)(b) of the Act, and 9(3)(b) outlines consideration that the minister will will contemplate in determining whether there should be a grant of a license under the Act. The OUR indicated that they should be given the same authority as set out in the Telecommunications Act. In relation to that, they should receive the applications and then advise the minister. However, prior to 2015, that was the role that the OUR was responsible for. But with the promulgation of the 2015 Electricity Act, the ministry is now responsible for receiving and considering applications for the grant of license. The minister, on many occasions, where the need arises, will request the OUR's assessment and recommendation. We do not believe that the Electricity Act should be amended to allow the OUR to have such responsibilities, because that is not the policy position of the ministry, and the Telecommunications Act has a separate regime where the OUR receives the applications and conduct their due diligence and advise the minister as to whether the application should be granted. It is the reverse in the Electricity Act, where the ministry receives the application and the minister issues based on the advice of the officers in the ministry. Now we move on to section 10, which deals with characteristics of electricity licenses. The PSOJ is requesting that the phrase "as the case may be" is removed from section 10, subsection 1B of the Act, and that provision provides that an electricity license granted under section 91A or C may be an exclusive or non-exclusive license, as the case may be, for any or all of the following services, namely the transmission, distribution, supply, or dispatch of electricity for the entire Jamaica or any part thereof. From our research, ordinarily, as the case may be, is often used to indicate that there are two or more alternatives. On a reading of the provision, we are of the view that if the phrase is removed, the substance of the provision would remain, and in that regard, we have no objection to the proposal. If there are no comments, I will move on to section 10, subsection 4, where the OUR is recommending.
Hold on, one second, Ms. Campbell. Remember, Paul, while you were saying something?
Right, I was noting the further recommendation that for the avoidance of doubt, consideration could be given to insert in between the words may and be the words either. Is that being recommended?
Yes, and my apologies, I overlooked it. Yes.
Okay.
So it may appear clearer, you know.
Okay.
Section 10, subsection 4, the OUR is recommending that the existing clause should be modified. The existing clause, which is in the middle column of your screen, says, An electricity license may include any restriction or condition, whether or not relating to the activities authorized by the electricity license, which appears to the minister to be necessary or expedient, and he may request the office to make recommendation in this regard. The OUR's proposal for a redraft states that the minister may, after consultation with the office and considering its recommendations, include any restrictions or conditions, whether relating to the activities authorized by the electricity license, which appear to the minister to be necessary or expedient. Now, when we considered the existing provision and the proposal, there is a similarity we found, but there is a subtle difference with the OUR's proposal. Based on our interpretation, I think the OUR proposal is seeking more to mandate the minister to consider favorably its recommendation before including any restriction. Now, we do not have an issue because OUR is the regulator. They monitor the licenses and they enforce the provisions in the license. But we believe that the current formulation is workable, and we would suggest that a full stop be inserted after the word expedient, and in the place of the comma, and a new sentence be added to say the minister may, in determining restrictions and conditions to be imposed on any licensee, consult with the office and consider any recommendations made by the OUR. We also thought it prudent to include a recommendation that the OUR gives its response in 15 days so that we do not have a delay.
So what I'm understanding the OUR to be saying is that no restrictions or conditions are to be authorized without their upfront consent. Minister, I find that to be a useful approach for your own protection, because it is really the OUR that determines whether or not a license is granted. They do, in effect, whether it's the electricity or telecommunications, they do have veto power, and in fact, the role of the minister is just signatory to these licenses. So I wouldn't have a difficulty with the way they have formulated it. It takes the minister out of it, not completely, but takes the minister, it diminishes the minister's role in the consideration given to the grant or not grant of a license, and also restrictions that are imposed therein. And I submit that it is the appropriate thing to do to have the OUR being that body that recommends a license and also recommends the restrictions or conditions that may impose. So I would go along with their formulation, but that's my view.
Thank you, Member Paulwell, and of course, with your background and experience, your input is valid. Ms. Campbell, okay, proceed.
A hand is raised, Minister.
Sorry, Minister.
Commissioner Green?
Yeah, through you, and apologies. I seem to be having some challenges with my camera systems. Apologies to the viewers who are, I know, tuned in. I appreciate Member Powell's position, and I know it has become customary for us to seek to diminish the role of ministers, especially in matters of this nature. But I think we have seen time and time again that matters may arise that require the minister to still reserve some form of authority that can be acted upon in a framework that, while it provides for consultation, does not neuter the minister's authority completely by demanding that that consultation must happen. So, you know, I am really minded to go with the formulation being proposed by the ministry that still includes that there is to be some consultation, puts in a sort of time frame for that consultation. But in my reading, is a little different from the OUR in relation to whether that consultation is sort of a precondition for the imposition of any restriction or condition. So, you know, I've seen in the limited times I've been in government that sometimes when we do these things with the best intentions and place a lot of authority and power in the hands of regulators, it doesn't always peter out to the benefit of the people. So we have to, there has to be a balance that is struck. And I find that the ministry's approach is a little bit more balanced than the OUR's approach. Thank you, Chairman.
And remember, all I will say in response to that, as you all will learn, is that it's a no-win situation when the minister is placed in that position. We have seen recent incidents in relation to firearm permit approval and reviews of those approvals. And the minister always takes the blame, even though there are bodies in between that ought to be responsible. I'm not hard nor fast on this, but all I'm cautioning, because I know the scenario that we operate in, that sometimes it is better to allow the regulatory agencies to shoulder these responsibilities and to relieve the minister totally of them. And even in those cases, it is always going to end up back with the minister being blamed, at least.
That is the point, Member Paulwell. That is the point that I sometimes have a hard time grappling with, because even when you do that, even when you divorce yourself of all the authority, it still comes back to the minister. And the worst thing I see is blame without authority. You know, so you don't have the authority to make any changes. And if something goes awry, it still comes back to you for the blame. So I understand, and you know, I really look on, because I know that well, you are a member of ours, have served in multiple capacities and have seen this from a number of different angles. But it oftentimes I see the direction, but you know, the blame is not going away. Blame is not going away.
Well, as I say, I really don't hold hard or fast on it, but I would be better able to defend the minister in Parliament when a controversy arises, if there is a body in between that would have been responsible for those decisions. But we can move on.
Members, you notice my silence on it, because I am fully aware of what can take place and what has taken place in the past. And unfortunately, some ministers are more targeted for blame than others. So I'll leave it at that. Ms. Campbell, go ahead.
Thank you, Minister. The OUR wishes the committee to consider in relation to section 10.5 that it is not clear where there is a reference to the payment of processing fee in section 10.5A1 as a license condition when that fee should have been paid at the time of applying for a license as per section 9.4 of the Electricity Act. In relation to that, the provision at section 10.5A1 says, without prejudice to the generality of subsection 4, and subsection 4 is what we just discussed in relation to the minister, including restriction or condition on any license. An electricity license may include any condition requiring the licensee to, 1, pay a prescribed fee on the grant of the license in addition to the processing fee referred to in section 9.4. Now, we don't have an issue with striking out the reference to 9.4, but we believe it's just to alert or remind us that their provision was made for a processing fee at section 9.4 and not necessarily for it to be a condition of the license. The OUR also recommends that the words and regulatory fees as may be determined by the office should be added to this provision, which outlines conditions that may be included in the license. We do not have any objection, really, although we note that the OUR, under the OUR Act at section 545G, that they have authority to impose their regulatory fee on any licensee or specified organization at rates they determine and publish by order. There is no comment. I'll move to the OUR's other.
Excuse me a moment, please.
Sure.
Sorry to interrupt, Chair. I'm not sure for the purposes of the record and the report that will be needed. I'm not sure. Is it that decisions are being taken now, or Ms. Campbell is just taking us through the comments?
Who is that? Member Gordon Campbell?
No, sir. This is Mrs. Beckford, who is recording, who has to do the minutes and so on.
If there's any suggestion that is to be made, members will interject as they have been doing and a decision taken. Is there anything that has taken place so far, members, that members have had would want to interject on and have not?
Well, not for me, Minister, but I'm wondering if Mrs. Beckford is referring to the previous clause that Minister Green and Member Paulwell might have had different views on. and therefore what would be the decision of the committee as to what we're proceeding with. If I'm incorrect, Mrs. Beckford, you can advise.
Ms. Beckford, is that the issue you're talking about?
Yes, Chairman. Thank you, Senator Alex.
You're welcome.
Okay, so
this is Marine Aldred.
Yeah.
Actually, really just for, I'm gonna say good form, we always want to make sure that we know that the committee has taken a decision. So, you know, just so that there is no misunderstanding and nobody can come at the end of a process and say, we didn't realize that we were taking decisions. I think it would really be better if at the end of each clause, you ask the question, does the committee agree, so that it can really be formally recorded that a decision has been taken. And then, yes, of course, especially where you have the conflicting views, you need to now have a recorded decision. Thank you, Chair.
Thank you, SG. Point taken. Point taken. So Ms. Campbell, I'd ask when you finish each just put it to the committee in relation to the previous clause with member Green and member Paulwell. Let's just go back to that and resolve that at this point. So member Paulwell, what I was hearing from you is that you really had no issue with what was being proposed.
Yes, the OUR's proposal was to mandate their upfront responsibility in the granting of a license for conditions to be imposed, and not really as an afterthought. And I thought that that was the best practice, that that will protect ministers. Certainly, it probably won't protect you, but it will give you some defense against ministerial overreach, that type of allegation. So yeah, I still put that there. I wouldn't argue strenuously much longer on it if the committee decides otherwise, but that will be my position. It might be useful to hear what the other members who can vote on this committee will.
Sure. Member Green, you want to just state your position again so that the members can be clear as to the two positions?
Yeah, so my position was more in alignment with the recommendation from the ministry that still took into account that the OUR would be included in the process, but formulated it in a different way. The OUR has kind of formulated a way that is a condition precedence that before anything happens, they must be included. The ministry has formulated a way in that they are to be included. There is a time frame for them to be included, but it's not necessarily a condition precedence for them to be included. That is my understanding of the formulation of the ministry. I just felt the OUR went a little too far in removing the authority, in my mind, of the minister. And I was saying that there has to be a balance between the authority of the minister and the regulator. And to the bigger point, that any way you take it, blame flows to the minister. So blame without authority is probably worse than blame itself. That's my view.
So you're supportive of the ministry's recommendation?
So I'm supportive of the ministry's recommendation that still includes the OUR, but does not have it as they have, that there must be included upfront.
Right. And member Paul is saying that he is not hard and fast in terms of that. Is there any other member that would like to make any contribution to this with a position so that we can just decide on it? All right, so I'm proposing that we go with the ministry proposal, based on the comments made by Member Green. Okay, silence is consent. We can proceed.
Sure.
And we'll follow SG's advice and just make sure that that going forward, we just clear, we get a consensus at the end of each of the clauses.
Certainly.
That would have been the only one that has been presented so far that had different opinions.
Yes, Minister. Now, OUR's comment on section 10, subsection 8, states that the subsection should not be restricted to generation licensees, but all licensees. It recommended that section 10.8 be deleted and a new provision be inserted at an appropriate location, which may read as follows. It is the duty of a licensee, let me read the current provision first. It is the duty of a generation licensee to ensure that the generation licensee does not commit an act or omission that will adversely affect, directly or indirectly, the security and stability of the system or the safety of the public. The OUR, in addition to recommending that it be removed from this section of the Act, also wants the provision to be made applicable to all licensees under the Act. Under section 2, an electricity license may be issued. Let me go again. In the definition of electricity license under section 2 of the Act, an electricity license means a license granted under this Act to do one or more of the following with respect to electricity, namely A, generation, B, transmission, C, distribution, D, dispatch, E, supply, and includes any existing license. So the OUR, so generation is just one category of license that may be granted under the Electricity Act. Now we agree with OUR's observation that perhaps that provision is misplaced. We recommend that it is removed to section 17. And section 17 of the Act deals with the duties of a generation licensee, and we recommend that this provision is removed and placed in somewhere in section 17, because generally the section 10 deals with characteristics of a license. Now we also note, to support our view that this provision is removed, to section 17, which deals with generation licensees proper, we note that section 22.2 has a similar provision, similar wording, and that section deals with the duties of transmission, distribution, and supply licensees. So the other licensees are covered. So you will note that the OUR has pointed out that the section 10.8 only refers to generation licensees. And in section 22, subsection 2, there's a similar provision, similar wording, and it also mentions a transmission, distribution, and supply licensees. So the other licensees would be covered there. The consideration of the committee would be required at this time.
So, Ms. Campbell, if I might, just for clarity,
Yes.
the change that is being proposed for Section 8, which is to make it for all licensees, in 22.2, it lists the licensees. So are we saying that 22.2 should also be amended just to say licensees? Or are you proposing that 10.8 should list, well, place now in 17, but list the licensees?
No, I'm suggesting that 10.8 be removed to sections 17 and the existing wording, meaning its reference to generation licenses only, be retained because section deals with generation licenses only.
Okay, I see. Understood.
Okay. And section 22.2 has a similar provision, similar wording, and mentions the other licensees like transmission, distribution, supply licensees. So the other licensees are covered.
Okay. So you're proposing simply to move it to section 17 only?
That is correct.
Okay. So are we going with silence means consent, or do we need to state, Minister? Categorically.
No, SG says that out of abundance of caution, she wants to make sure that we put everything. So
understood. I'm satisfied with this.
All right. If no other contributions, we go ahead and approve that.
So we have a comment from Gerald Lindo in relation to section 10. He has a subheading, creating a new category of license for energy storage. I'll read what he says. As more viable renewable energy generation becomes a part of Jamaica's energy system, more energy storage solutions must be brought on the grid. None of these services fits neatly into the categories of licenses contemplated in Section 10 of the Electricity Act. The Act thus does not currently allow for these technologies to be deployed in an orderly way that gives equal opportunity to all investors. The Joint Select Committee should consider amending the law to include a new category of license for ancillary services that would allow for energy storage assets to be interconnected and leveraged by the system operator. This would allow for more innovation in energy projects, including in emerging electric vehicle to the grid technologies, to the benefit of the system operator and asset owners alike. Now, this proposal was considered, and the ministry does not see the need for the creation of a special category of license for energy storage. Energy storage at the distribution level is captured on the net billing application process and licensing. The technical people may provide a better explanation should the committee require.
Could I just ask a question now, Minister? Because some months ago, I asked a question about those installations that will provide recharging facilities for electric vehicles. And I think you did say that those will not require an energy license. So perhaps if you could just restate that now, because that would therefore set some people's minds at ease who believe now, I don't know why they have this view that they have to get a license to establish these facilities across Jamaica. Is there a regime for it, license or no license, Minister, for those persons who wish to establish these facilities to charge or recharge batteries on electric vehicles?
That matter was raised and I gave a clear directive on it. Mr. Richardson?
Minister, with regards to the review that we have done, there is nothing that suggests that a license is required. I think applicants are going directly to the JPS to seek to put charging stations at their points of interest, and they're working with the JPS.
And when you say go to the JPS, what is the role of the JPS in this?
The charging station is connected to the grid. It's not independent of the grid. And so the JPS has to play a role in that, sir.
Yeah, but it is conceivable, and many people do accept that charging stations can be activated and supplied from renewable energy. So in that case, would they not be standalone units, which wouldn't require JPS involvement because it's not connected to the grid?
That I'm not sure I have clear information to respond to that. I'll do my best to look into it. But my understanding is that let me look into it because I'm not sure how that would actually work.
I think what the member is saying is that we have to have a clear set of protocols in relation to that, and that would be obviously both the connection to JPS and then without, because there is a misconception out there or misinformation out there that needs to be clarified. Remember, I will get on to that and make sure that matter is clearly defined and stated.
Yeah, because as you quite rightly had put it, you want this area to be freely competitive, that there be no barriers to entry, that if we're going to build out electric vehicles, an architecture for electric vehicles, then people must be able to, wherever in the island they go, have access to charging facilities. And you won't have that growth taking place if there's anybody in the system who can exercise veto power. And that the only consideration must be standards that are set, not by JPS, but I suspect the Bureau of Standards that will govern these. But I believe it is quite possible that a solar facility, properly configured, can become charging stations for electric vehicles. And that should be the policy.
Noted. Mr. Campbell, continue.
Section 11.
Ms. Campbell, I believe we lost your screen.
Oh, I'm sorry. Let me share.
It's a good thing your desktop is not as interesting as mine, otherwise we would see interesting things.
Are you seeing it now?
Yes.
Okay, thank you. The section 11 of the...
I'm sorry, Ms. Campbell. Minister, since we are awaiting the protocol from the ministry based on what you have indicated will be the next step, are we saying that this section we wouldn't make a decision on it? Or until we get that?
I don't think we need to. I think once a principle is established that based on member Paul's comments, and it should be reflected as such. Okay. The protocols is not necessary for the actual clause. You noted that member. Sorry, you noted that, Ms. Campbell?
Yes, ma'am. We move on to section 11, which provides for a register to be kept. The PSOJ is recommending that that section 11 to be amended to include such register, to include their phrase, such register shall be published on the ministry's website and shall be kept current by being updated at least annually. The existing provision says the minister shall cause a register to be established and maintained in which the particulars of each electricity license shall be entered. We do not have an objection necessarily to the PSOJ's recommendation, but we wish to suggest that that particular provision is amended to include the following: that all licenses issued under the Act to be kept and maintained in the register. The register is to be kept in such form as the minister deems fit, including by electronic means. The register is to contain the date licenses were issued, the date of expiry, renewal, or revocation, and it should contain information on the name, address, and description of licensees. The register should also contain information on the type of licenses issued and the purpose for the grant of the licenses that have been issued. The register is to be made available for inspection by the public, whether by electronic or means or otherwise, and it should also include such other pertinent matters concerning licenses. The committee may now opine. I suppose that's approval, so we may proceed.
Let me just do it formally.
Okay.
Okay, so accepted, unless we have any interventions.
Accepted, Chair.
All right, proceed.
Section 12 of the Electricity Act has provision relating to the restriction on the transfer of electricity license. It says no electricity license shall be transferable to any other person without the approval in writing of the minister, and before making his decision whether or not to give his approval under this subsection, the minister may seek the advice of the OUR, the office. The OUR, in relation to this provision, says that the prohibition on the transfer of license without the approval of the minister should also include similar restrictions on an assignment or transfer of control of the licensee. This will ensure that the government and regulator are not only aware of the ultimate owner and provider of the service, which may change over time, but they are given the opportunity to assess the suitability of such persons to have or control the license and licensed business. We agree with the OUR's recommendation that there should also be provision in relation to assignment of any license, as there is none in the current Act. We looked at the Electricity Act in India, and we found guidance. Now, they have a provision which prevents the licensee without the approval of the appropriate commission. And the appropriate commission includes the regulator to undertake any transaction to acquire, buy, purchase, or take over, or otherwise the utility of any other licensee. We are not adopting that one, but we have also looked to subsection 2, which says that every licensee shall, before obtaining the approval under subsection 1, give not less than 1 month's notice. No, that's not the section. It's actually subsection 3. No licensee shall at any time assign his license or transfer his utility or any part thereof by sale, lease, or exchange, or otherwise without the prior approval of the appropriate commission. And subsection 4, which says any agreement relating to any transaction specified in subsection 1 or subsection 3, unless made with the prior approval of the appropriate commission, shall be void. So we considered to adopt in relation to our agreement with the OUR to also prohibit the assignment of any license without the approval of the minister in our case, and the provision in relation to which makes void any transfer or assignment without the prior approval of the minister. And we actually have that provision in relation to the transfer. We suggest that we retain that in relation to an assignment. So our proposal in relation to an amendment of section 12 to also include a prohibition on the transfer by an assignment without the prior approval of the minister should consider the following. 1, the prior approval of the minister is to be obtained for transfer, where the licensee transfer the operation of the licensed facility by sale or otherwise its rights, obligation under a license or part thereof, or control as the OUR suggested. 2, that prior approval of the minister is obtained for the assignment or any decision of the licensee to encumber its license, its rights or obligations under the license. There is a timeline of 30 days that we considered appropriate for the minister to respond to any such request following from the date of receipt of the request. We also consider it prudent for the OUR to be consulted and its opinion obtained before the minister responds to any such request. And we thought it prudent to include that the minister's consent should not be unreasonably withheld, and we wish to add that any such request should be made in writing to the minister with any justification that might be appropriate.
Silence is consent. With that, we can proceed.
Section 13, subsections 6. Says that where the licensee is a party to an agreement with the single buyer for the sale or other supply of electricity to the single buyer, a breach of that agreement by the licensee or the single buyer shall constitute a breach of the electricity license held by the licensee or the single buyer, as the case may be, for the purposes of subsection 1B. However, this subsection shall not apply to an existing license unless that existing license so provides. The OUR comment. It should be an unresolved breach of the agreement between the single buyer and the licensee that should constitute a breach of the electricity license. These agreements usually make provision for the remedy of a breach. A contractual breach should therefore not automatically result in a breach of the license. Also, see comments below on the proposed role of the OUR in resolving breaches. So in relation to the provision, we accept the OUR's recommendation because they are the ones who approve the terms of these agreements. They would usually have a provision which allows time for the party in breach to remedy a breach. And so we consider that on that basis that we would accept their recommendation.
Chair, if I might, I'm really not opposed to the recommendation, but I'm kind of wondering the necessity of it. We do, section 13(6), in reference to 1B, which is the power of the minister to revoke a license. The language in 1B talks about if the minister is satisfied. So if the minister may revoke or suspend for such period as he thinks fit. If he's satisfied that the licensee has breached any of the terms or conditions, if any, for any of the terms or conditions of the license and the period provided, if any, for remedying has expired, it would appear to me that what the OER is contemplating is really already covered in the provision. I'm not really seeing the distinction and the need for the amendment.
Ms. Campbell, any response to that?
When we considered the OUR's comments in relation to the provision, we agreed with the OUR's view for the reasons that they have stated.
I didn't get that good. You kind of was muffled. Say again.
No, when reviewed the existing provision and considered the OUR's proposal. We agreed with the OUR's proposal for the reasons that they have stated.
Can I just understand the justification of this? I really am not understanding, and I'm I don't want to belabor the point too long, Chair, but I'm looking at this from the perspective of the licensee, right? If a licensee is in a situation where there's a breach of the license, the amendment that the OUR is proposing would change what from what currently exists? What would be the change?
Ms. Campbell, you may respond to that?
Yes, Minister. I'm just refreshing my memory here. Could you repeat, Senator Campbell?
I'm trying to understand, Ms. Campbell. I'm trying to understand what the proposed amendment that the ministry is agreeing to is going to effect. What is going to be the effect of the proposed amendment that is going to change what currently exists?
In my thinking, the breach of the terms of any agreement would not automatically result in the breach of in a revocation, in providing grounds for the revocation of the electricity license from which that agreement was crafted. That was how we looked at it, and if the breach is unremedied, then that would provide the basis for the revocation of the license.
But the problem with that is that it creates a regime in which a licensee can breach the agreement, and so long as it's remedied, then there is no, in other words, you can have multiple breaches, but as long as you remedy it, then there's no revocation that's possible. Whereas what we have currently existing is that if you breach the agreement, it provides the grounds for the minister to act, but the minister doesn't act automatically. He has a discretion to act, that he must then consider the circumstances, which would include whether or not the breach is remedied, and then he can determine how he acts, for what period the action is to take effect. If you put in the word unremedied, then what you have said is the agreement is really of not much effect, because I can just breach anytime I want, but just as long as I remedy before you act, then I can go on. I don't think that that doesn't sound like an advisable position for the state to be in relation to licenses.
As to say, Chair, I strongly agree with the views expressed by Senator Gordon Campbell. I don't think I have to add anything else.
Any other comments from any members? So, Member Golden Campbell, what is your proposed change?
In relation to this, Chair, I am proposing that it remain as is. I am proposing that the minister retain the discretion to act if there's a breach of the agreement, and that the OUR's proposal not be accepted in this scenario, because it's not the correct view to state that there's an automatic revocation or suspension. 1B puts you in the position of having to consider the possibility, and that, Chair, is where the discretion can be exercised or not exercised. But removing the discretion to act if there's a party breaching multiple times, you know, I can just imagine as I live in the commercial world that, you know, even for the purposes of cost and saving costs, you breach a license and then you remedy. You breach it and then you remedy. And, you know, I just don't think that's an advisable position. So my proposal, Chair, is that that we retain the provision as is.
And Chair, just to say, I again agree with Senator Golden Campbell. I think what is bestowed upon the minister is a discretion. There's no automaticity. You do not, it says may, you may revoke, you may suspend. But the power that is being bestowed upon the minister is that if there is a breach, you may do these things. I absolutely do not believe that we should include the terminology unresolved breach. Then you're going down a rabbit hole of even, you know, how do you define an unresolved breach? If I have started to remedy it, am I on the road to resolution? It should remain as is.
Noted. If no other comments, we will accept the recommendation of Member Golden Campbell and reiterated by Member Green. Please note that, Ms. Campbell, and proceed.
Section 14, failure to comply with directions of the office. The OUR's proposal is that Section 14 should be reviewed. Perhaps the provision could be linked to the minister's power of suspension and revocation of license in Section 13. For example, the provision could be revised to require that the office should notify the minister of licensee actions or omissions that would trigger the powers of suspension or revocation and the processes under Section 13, and the office should provide the minister with its recommendation for action in this regard. The current provision reads, if the office is satisfied that an electricity licensee is likely to contravene or has contravened any condition of the licensee's electricity license, any of the codes, any provision of this act, or any regulations made hereunder, or any direction issued by the office, to or applicable to the licensee, the office shall forthwith notify in writing to the minister thereof, and may provide the minister with such recommendation as it considers appropriate. We do not have any objection with attaching that provision to Section 13, which deals with the subject matter of revocation.
Yeah, I'm sorry to intervene. I think I'm making the same point in relation to this provision. And I hear the minister agreeing, but what are you agreeing with? Because you already have exactly what they're saying existing in law. Section 14 says that the OUR shall notify forthwith in writing to the minister where a licensee is contravening, is likely to contravene, or has contravened. The OUR has shall duty. They must notify the minister in writing, right? So once they notify the minister in writing, Section 13(1) applies. It's already connected. It says the minister may revoke, suspend, or revoke or suspend if the licensee has breached any terms or conditions of the license. So if the OUR is notifying that the licensee is contravening the conditions of the license, then 13 is in place. There's no need to twist our minds anymore. We have exactly the provision existing in law. I apologize, sir. I didn't realize my video was off.
Ms. Campbell, you want to respond to that, any member?
Chair, our position is that we were not agreeing to any changes to the substance or the language of the provision. But since there is a nexus with Section 13, perhaps it could be attached to it. That was the extent of our consideration. And we have no objection if it remains in the place as Section 14, because it doesn't change the substance of the provision, which was what we were not agreeing to the change of the substance of the position in Section 14, but because it had a nexus, a link with Section 13, then we didn't have any objection if it could be moved up there, subject to drafting rules.
My intervention was that it exists already. So this proposal by the OUR doesn't move us anywhere different than what already exists. So there's no need to labor over this. Let us move on. It exists already.
So we're saying, Senator Golden Campbell, that there's no need to contemplate this proposed change then?
No, Senator Allen, it exists already. Section 14 says the OUR must notify the minister where the licensee is contravening the license. It even has a duty to notify the minister if it thinks the licensee is going to contravene the license.
Once
it does that, once it notifies the minister and the minister is aware, then the minister may act under his discretionary powers under Section 13.
Okay, so is there any opposing view that is held by the technical team at the ministry then? Because that sounds simple to me.
What I'm getting from Ms. Campbell is that she's not opposed to it either.
Not opposed to not making the change? I'm confused.
Okay, so see, that's the part where we're twisting up, and that's what I don't want us to do. There is no change. The OUR has simply stated that it wants something that already exists. So, there is no change being proposed. What they have proposed is what already exists.
Okay. So there's nothing to consider then?
There's nothing to consider.
Members, is that accepted?
Minister, I think someone on your team is seeking to make an intervention.
Who is that?
Peter, I don't know. Peter Simmons.
Is there somebody who wants to make a contribution? Please identify yourself and your title.
Peter Simmons is legal reform.
Legal reform? Department LRD?
Seems his microphone might not be working.
Microphone not working, or are you on mute? All right, let's see if he gets his microphone back. But in the meantime, Ms. Campbell, are you understanding what Ms. Member Golden Campbell is saying?
Stand clearly, Minister.
All right, we'll wait on LRD to come in, and then we'll take a final position. But please note what has been proposed. LRD, you need a new instrument. We await you. Go ahead, Ms. Campbell.
Section 15. Failure to comply with directions of the office. The current provision reads, a licensee who after investigation is determined to have failed to comply with any direction given by the office under this act commits an offense. The OUR, its contribution
if I may, Chair, this is the Legal Reform Department. Or technical issues have been resolved. So if we may proceed to making our comment at this time.
Very much so. Go ahead, please. On the matter, the previous matter that Member Campbell.
Yes, Mr. Chair.
Yes.
I don't have the matrix. I was just looking back at the recommendation made by the OUR with regards to section 13 and the committee's decision not to accept the recommendation. But I think we're confusing was actually referring to, there are actually two things at play. An agreement with the single buyer for sale or other supply of electricity, as well as the electricity license itself. Now 13.1b is speaking about suspending where there's a breach of the electricity license. But 13.1.6 is speaking of a breach of the agreement. So where there's a breach of the agreement, it shall constitute a breach of the electricity license. But what the OUR is saying is that these agreements not provide for breaches to be remedied. So the recommendation from the OUR is saying is that where there's an unremedied breach of the agreement, that is where it shall be a breach of the electricity license. So in other words, the person who has the agreement with the single buyer must be given the opportunity to remedy the breach before it can be a breach of the electricity license.
And Chair, I think my concern is no different. While the so if the agreement allows for the licensee to remedy a breach, and usually it will indicate the timeline, whether it's reasonable time or some period of time, then that licensee is operating within the strictures of the agreement. So the breach of the agreement, in my view, doesn't really arise until those processes have expired, or rather, the breach is not actionable by the parties until that process has expired, the opportunity to remedy, the failure to remedy, etc. So if that is the case, then the license, the discretion given to the discretion given to the minister in 13 would not be reasonably exercised if a minister were to act by not allowing the framework or the regime under the agreement to play out before revoking the license. OUR is saying an unremedied breach of the agreement is what must trigger the discretion. I am still saying that the discretion ought to remain in either situation so that at the end of the day, the state can intervene if it needs to intervene. In an unremedied breach situation, if you always have an agreement that is constantly being subject to breaches of the agreement that are then remedied, the state under the OUR's proposal has no discretion to act. And that is my concern. So thank you, LRD. I'm not sure who was speaking just now, but thank you for that. I appreciate the clarity that you were bringing. I hope you appreciate the point I am making. Here, can I just say further, you know, I am not usually a proponent of giving the state a whole lot of power, you know. I'm not usually a proponent of that. But in this particular sector and in this particular situation with such a critical utility, I think it is important that where actions are being taken, where omissions are being made, that there is some discretion for the step in.
So, Member Campbell, you have made your position very clear, and as before, reminded to support it unless there's any other point to be raised.
My only further comment, Mr. Minister, is that if the agreement that you have with the licensee is that you are allowing for the breach to be remedied, I can see the point being made by the OUR that is a term that you'd have to honor because it's a part of the agreement that they'll be allowed to remedy the breach before you consider it to be a breach of the electricity license. That's it.
Is it Mr. Simmons? Is it Simmons? I'm so sorry. I don't see it. Is it and so what you just said just now, wouldn't that be encapsulated in how the minister exercises his discretion? Wouldn't it be captured there? What's your view on that?
Well, the way it is currently worded, this is it at 13.6, is that once there's a breach of the agreement, it shall constitute a breach of the electricity license. That's how it is worded, full stop. And what the OER is saying, since the agreement allows all breaches to be remedied, it should be an unremedied breach of the agreement before the minister can say it is a breach of the electricity license.
Okay, I see what you're saying. And Chair, I wonder, and I would take some guidance. I'm not seeing Parliamentary Council on this, but would the insertion or the replacement of the word shall constitute a breach in subsection 6, if we were to replace that with may constitute a breach, to keep it within the discretion of the minister to act, would that, Mr. Simmons, in your view, be a middle ground between my position proposed to the committee and the OUR's concerns.
Well, RD, we're waiting on you to respond.
Oh, may could be a better word, but I'll still leave it to the, or maybe allow the Parliamentary Council or to consult with them to see what their final position is. But I think may could be a better word to use, or as a proposal is by the OUR.
I am not in support of the OUR's proposal to say unremedied breach, because I am concerned. I'm concerned about multiple breaches being permitted in an agreement that affects others, but you can't act to deal with such a party, because every time there is a breach, there is a remedy. And so the proposition of may replacing shall, I think the intent, in my view, Minister, would be to allow for a determination to be made as to whether or not the circumstances warrant it being considered as a breach of the license, and then, of course, the discretion to act under 1B would arise, or subsection 1 would arise. But I just wanted to elaborate a little bit on the explanation I was giving. I too defer to the drafters in relation to how to capture that.
Do we have the CPC online?
Hello. Yes. Good morning,
Morning,
Chair.
morning,
I'm going to turn
morning.
on my video. I'm sorry. I
Sure.
can't. I'm having an issue with the
No
hands up.
No
Finding
problem.
the hand.
Go right
Okay.
ahead. Go right ahead.
Hello. Good morning. Okay. So in terms of my intervention, I think fundamentally this provision strikes me in a number of respects. And one of the things I found interesting with it, and this is section 13.6, is it appears to contemplate some sort of transition as well from a pre-existing situation or that existed before this particular piece of legislation came into being. So one of the things I note is the statement, the last two lines of subsection 6, which says, however, this subsection shall not apply to an existing license unless that existing license so provides. And so for me, one of the questions that the provision raises is what exactly is for someone who is not familiar with the area, what is the relationship between the agreement by the licensee or the single buyer in relation to the license held? How does that work? I think it would be useful to understand how the agreement informs or is encapsulated or dealt with in the context of a license. In terms of changing shall to may, it's a little more than simply a matter of drafting technique. I think we have to be very clear on what the policy currently is and what the policy intent is in terms of what we seek to achieve. Thank you.
Member Golden Campbell, you have anything to say on that?
Well, Chair, actually, I think this is something, and given Ms. Eaton's intervention, thank you very much. I think it needs some contemplation by the ministry in terms of of policy. And the question is, well, I think Ms. Eaton articulated it quite well. How do we wish to see the minister exercising his discretion in relation to revocation and suspension vis-a-vis breaches of agreement and breaches of the license? What's the nexus between the two? How do you want that to work? And so I think it perhaps needs some better and perhaps more in-depth contemplation from a policy level. If we can understand what the policy is in terms of how you want those two to be linked or not linked, then I think I would be in a position either to push further my point or to concede it.
All right, so what we'll do is we'll refer this, have some more discussions internally and come back to it at the next meeting. In the meantime, Ms. Campbell, you have further discussions with LRD and CPC. Sir Richardson. All right. Proceed, Ms. Campbell.
Section 15, failure to comply with directions of the office. The section provides that a licensee who, after investigation, is determined to have failed to comply with any direction given by the office under this act commits an offense. The OUR contribution in section 15, it is suggested that the express power of the regulator to investigate a licensee's conduct and its operation to ascertain whether it has contravened any of its obligations or whether the interest of the public is adequately protected, akin to such powers contemplated in the OUR Act and the Telecommunications Act, be included. The regulator is empowered to give directions in relation to its findings. Failure to comply with such directions constitutes an offense. In considering the provision vis-a-vis the proposal, we thought that the section could be amended to expressly provide for the OUR to investigate the operations of a licensee and to give direction in relation to its finding. And we have no objection to retaining the offense that is there.
Mr. Minister. Mr. Chair.
Yeah, go ahead, Mr. LRD.
Yes. Just to backtrack again, just have a second look at section 14 of the Electricity Act. I just want to point out as well that for section 14, we're not only dealing with a breach of the electricity license, but also any of the codes, any provision of this act, or any regulations, or the direction of the office, or anything applicable to the licensee. So it's not only the license, which is why I think the OUR was saying that section 14 should be linked to section 13. It may be a matter of drafting as well, but I just want to put that point on the table.
Noted. Campbell, continue.
Chair, maybe indulgence on what Mr. Simmons was saying just now, with which I agree. But a breach of the code, a breach of the act, and a breach of the regulations would trigger whose action? Because the minister is not the one who is enforcing the law. If there's a breach of the act or the regulations, isn't that something that then becomes a matter for prosecution? No, yes.
I think it would depend on what in the act or the regulations, directions, so on that would be breached. So I don't think it's necessarily a matter for prosecution.
Right.
But I think but basically I think the power that exists in law is that if you have a license, it can be revoked or suspended by the minister. So maybe I'm not aware of all of the legal infrastructure surrounding it. But if it is that this is a power that the minister has where there is such a breach and the OUR will notify the minister of these breaches, then the minister can then act on the information given to the minister by the OUR.
But the minister is not limited to acting only on notification by the OUR. If something comes to the attention of the minister that would fall within paragraph, say to D, the minister can act without any notification from the OUR, can't he?
Yes, that is so.
Okay, I'm gonna also give you some more contemplation, and I will await where the ministry comes on this at the next sitting.
Noted, member William Campbell. All right, so MSET team, you're offering what has to take place for the next meeting in this matter, in relation to this matter.
Absolutely, Chair.
All right, proceed.
I'm Chairman.
Right, member.
Yes. I'm so sorry. I have been a bit distracted for the last half an hour or so. Could you say what time we're going to go until today?
We're going to wind down now. We finish by 12:30. Another 10 minutes or so.
All right. Well, I'm back.
All right. Great.
So, Chair, might we have a decision on section 15?
Sorry, just for clarity, this is in relation to the OUR's recommendation. Yes? Okay. I'm in agreement with the recommendation, Chair.
Noted.
Should I proceed, Chair?
Say again?
Should I proceed?
Yeah, sure. Go ahead.
Chair, I don't know if based on SG's guidance to you and your comments earlier, the other members would wish to indicate.
The other members would wish to what?
indicate their agreement or not with that provision. I don't know if it was put to everybody else. I don't want my my
No,
voice was a low voice.
So the truth is that we put it, and if there's no no intervention, then we take it.
Are we talking about section 15?
Yes, that's where we are. Is that what you're talking about, Senator Campbell? Golden Campbell?
Yes. Section 15.
Yes, I agree with it.
All right. Proceed, Ms. Campbell.
Section 17 has 3 subsections, and it deals with the duties of generation licensees other than self-generators. Subsection, the OUR has asked us to look at subsection 17(1), and they note that subsection 17(1) says, subject to subsection 2, it is a duty. I'm reading the existing provision, so let me start there. Subject to subsection 2, it is the duty of a generation licensee to develop and maintain a reliable, efficient, compatible, safe, and economical system of electricity generation in accordance with the electricity license held by the generation licensee and the generation code, this act, and any regulations made hereunder. Subsection 2 says subsection 1 shall not apply to self-generators. Subsection 3 says, for the purposes of subsection 1 and section 18(1)(b), a system of electricity generation shall be considered compatible if it complies with the provision of this part. OUR's comment, this provision states that subsection 1, in reference to subsection 2, states that subsection 1 shall not apply to self-generators, only generation licensees. However, the identical provision exists at section 18(1), which deals specifically with self-generators. The inclusion of both sets of provisions, that is section 17(1) and subsection 2 of section 17 and section 18 subsection 1 seems superfluous. It is of note that although the marginal note indicates that the provisions of section 17 relates to the duties of generation licensees, but not self-generators, subsection 3 of that section expressly includes self-generators in its application. It is proposed that section 17 be reviewed. Perhaps the section can be made applicable to generation licensees and self-generators who hold a license, and then section 18(1) be deleted. The marginal note would have to be adjusted to reflect duties of generation licensees and licensed self-generators. Having read the section 17 and section 18(1), we support the view that 18(1) should be deleted because the requirement for section 17(1) is similar to what is provided in section 18(1). So there are self-generators who are required to adhere to the same standards in section 17.1 that is outlined in section 18.1. And these self-generators are net dealers, wheelers, and they're also generation licensees. So we have no objection to the OUR's proposal in relation to that.
Just to be clear that we understand the various descriptions. There's a definition, or there's a distinction now between a self-generator and a licensed self-generator.
Yes.
Because a self-generator, like myself, don't come within the framework, strictly speaking, of the law, but it is only those that get a license from the minister that the law is seeking to regulate. So if we're clear on that, and that this only applies to licensed self-generator, those who have a net billing arrangement or wheeling and so on, then I'm fine with this proposal. Ms. Campbell? Right, we are clear on that.
Right, because it's section 17, subsection 2, exempts self-generators. So the licensed self-generators are required to comply with those standards, and those are the ones that are captured.
Right. Right. So in the discussion, you should really at all times specify that we're talking about licensed self-generators. Are you a licensed self-generator, Minister, by the way?
Soon to be.
Well, be careful, eh? I am not a licensed self-generator. I generate my own electricity without a license. Minister, I was just thinking, we do have another meeting at 2, the Energy Council.
Yes, yeah, I'm going to close off now. 20 minutes.
Yes, okay.
All right, Ms. Campbell, where are you now?
We're at section 17, Chair.
All right, finish up that and then we can call it.
We're finished. That was the only comment on section 17 from the OER.
All right, so we can move that.
Do we have a decision? Are we taking the decision now or?
Yes, sure. Sure. Remember, Paul, that I say he doesn't have any issue. I'm not hearing anybody else, so we can put it forward. All right. Well, that would carry us to the end. We'll take another one. It's 12:26. All right. So before we wrap up, we have the minutes of the meeting held January 6, 2022 and March 15, 2023. Can I have
July, Minister, not January, July.
July, that's correct. July 6, 2022 and March 15, 2023. Can I have somebody move to confirm those minutes?
I will move to confirm March 25. Is it March? Sorry, March 15.
March 15, 2023. Moved by Member Allen, seconded.
I'll second that.
Member Paulwell. And then we have July 6, 2022. Did anybody get a chance to go back through those minutes?
Not I, Minister. Sorry.
All right, anybody else got the opportunity to go through those minutes? If not, we can put them to the next meeting and ask that you do them so we can take them at the beginning of the next meeting.
Okay. Chair, I do recall chairing that meeting, but I too have not had a chance to get through those minutes.
All right, we'll take them for the next, at the beginning of the next meeting. Any matters arising from the minutes of the meeting on March 15, 2023?
Could you hold those until the next meeting, please?
All right. So I'll ask the members just to go back through those both so to see if there's any matters arising from the confirmation of the minutes March 15, 2023, and for the confirmation of the meetings for July 6, 2022, and any matters arising. All right. So members, we are scheduled to have another meeting Thursday, April 20, 2023 at 10 a.m., which is next week, Thursday. And we would want to set some new dates. I don't know if Ms. Beckford, do you have any proposed dates for us now, or you want to wait until the next meeting?
Not at this time, Chair.
We don't want to lose the momentum, so we need to make sure that we have slots. We don't want to wait to the last minute and then find that the slots have been taken by other joint select committees. So please, don't wait until the next meetings. Find out and send it through to us, and we can circulate it and confirm even prior to next week, Thursday.
Yes, Chair.
All right, we want to keep the momentum going and get this to the point of where we can actually have it finalized for the members' signature and for to be tabled. All right, members, thanks again for all the interventions. And we have one matter that will come back to us for the next meeting that MSET team will do some work on. And we will meet again on the 20th of April at 10 a.m. Until then, keep safe and all the best. Thanks to the supporting staff from Parliament and all the other agencies, SG, CPC, LRD, everybody. Thanks so much.
Okay, good afternoon.
Afternoon.